In the case of minors Oposa et al. Versus Factoran et al. GR number 101083, July 30, 1993, the court allowed minors and even unborn to be complainants to a citizen suit for environmental loss. Supreme Court stated, this petition bears upon the right of Filipinos to balanced and healthy ecology, which the petitioners dramatically associate with the twin concepts of the intergenerational responsibility and the intergenerational justice. Specifically, it touches on the issue of whether the said petitioners have a cause of action to prevent and misappropriation or impairment of the Philippine rainforest and arrest the unabated hemorrhage of the country's vital life support system and continued rape of the Mother Earth. The controversy started in the civil case filed before the McCarthy RTC. The principal plaintiffs are all minors duly represented and joined by their respective parents. Impleaded as an additional plaintiff is the Philippine Ecological Network Incorporated, a domestic, non-stock and non-profit corporation organized concerted action geared for the protection of our environment and natural resources. Original defendant was Fulgencio S. Factoran Jr., DNR Secretary, substitute by a new secretary, the Honorable Angel C. Alcala. The complaint was instituted class suit and alleged all citizens of the Philippines and entitled to the full benefit, use, and enjoyment of the natural resource treasure that is country's virgin tropical rainforest. The minors asseverate that they represent their generation as well as the generation of unborn. Consequently, it is prayed for that the judgment be rendered, ordering defendant, his agents, representatives, and other persons acting in his behalf to: first, cancel all existing timber license agreements in the country; second, cease and desist from receiving, accepting, processing, renewing, or approving new timber license agreements, and granting the plaintiffs such other reliefs just and equitable under the premises. The complaint issue focuses on one specific fundamental legal right, the right to a balanced and healthy ecology, which, for the first time in our nation's constitutional history, is solemnly incorporated in the fundamental law. Section 16, Article 2 of the 1987 Constitution explicitly provides, the state shall protect and advance the right of the people to a balanced and healthful ecology in accord with the rhythm and harmony of nature. This right unites with the right to health, which is provided for in the preceding section of the same article. Section 15, the state shall protect and promote the right to health of the people and instill health consciousness among them.
Issue: whether or not the right to a healthful ecology be granted to minors and future generations. The decision is yes. While the right to a balanced and healthful ecology is to be found under the Declaration of Principles and State Policies and not under the Bill of Rights, it does not follow that it is less important than any of the civil and political rights enumerated in the latter. Such a right belongs to a different category of rights altogether, for it concerns nothing less than self-preservation and self-perpetuation, aptly and fittingly stressed by the petitioners, the advancement of which may even be said to predate all governments and constitutions. As a matter of fact, these basic rights need not even be written in the Constitution, for they are assumed to exist from the inception of humankind. If they are now explicitly mentioned in the Fundamental Charter, it is because of the well-founded fear of its framers that unless the rights to a balanced and healthful ecology to health are mandated as state policies by the Constitution itself, thereby highlighting their continuing importance and imposing upon the state a solemn obligation to preserve the first and protect and advance the second. The day would not be too far when all else would be lost not only for the present generation, but also for those to come generations. We stand to inherit nothing but parts of earth incapable of sustaining life. The right to a balanced and healthful ecology carries with it the correlative duty to refrain from impairing the environment, conformably with the enunciated right to a balanced and healthful ecology and the right to health, as well as the other related provisions of the Constitution concerning the conservation, development, and utilization of the country's natural resources. Then, President Corazon C. Aquino promulgated on June 10, 1987, Executive Order No. 192, Section 4 of which expressly mandates the Department of Environment and Natural Resources shall be the primary government agency responsible for the conservation, management, development, and proper use of the country's environment and natural resources, specifically forest and grazing lands, mineral resources, including those in reservation and watershed areas, and lands of the public domain, as well as the licensing and regulation of all natural resources, as may be provided for by law, in order to ensure equitable sharing of the benefits derived therefrom for the welfare of the present and future generations of Filipinos. Section 3 thereof makes the following statement of policy. Both Executive Order No. 192 and the Administrative Code of 1987 have set the objectives will serve as the basis for policy formulation and have defined powers and functions of the DENR.
May, however, recall that even before the ratification of the 1987 Constitution, specific statutes already paid special attention to the environmental rights of present and future generations. June 6, 1977, T No. 1151 for the Philippine Environment Policy, PD No. 1152, Philippine Environment Code were issued. The former declared a continuing policy of the state. First, to create, develop, maintain, and improve conditions under which man and nature can thrive, productive, and enjoyable harmony with each other. Second, to fulfill the social, economic, and other requirements of present generations of Filipinos. And third, ensure the attainment of an environmental quality that is conducive to a life of dignity and well-being. Its goal, it speaks of the responsibilities of each generation, trusting guardian of the environment for succeeding generations. Other statutes, on the other hand, flesh said policy. The right of the petitioners and all those they represent, balanced and healthful ecology is clear. The DNR's duty under the mandate and by virtue of its powers and functions. Their EO number 192 and the Administrative Code of 1987 to protect and advance the said right.
On the second point, a denial or violation of the right by the other has the correlative duty or obligation to respect or protect the same give rise to a cause of actions. Petitioners maintain that granting of the timber license agreement, which they claim was done with grave abuse of discretion, violated their right to a balanced and healthful ecology. Hence, the full protection thereof requires that no further timber license agreement should be renewed or granted. After a careful examination of the petitioner's complaint, we find that statement and the allegations as an introductory affirmative defense, as well as the specific affirmance under the subheading cause of action. Also, it is adequate and enough to show prima facie violation of their rights, particularly under Article 2, Section 16 of 1987 Constitution. Thus, the basis thereof, they may be granted wholly or partly on their leaves prayed for.
The Oposa case is also famous internationally because the court recognized the right of the petitioners, who were minors, to sue as a class on their own and as representatives of generations yet unborn, based on the concept of intergenerational responsibility. This case, however, has a special and novel element. Petitioners' minors assert that they represent their generation as well as generations yet unborn. We find no difficulty in ruling that they can, for themselves, for others of their generation, and for the succeeding generations, file a class suit. Their personality to sue in behalf of the succeeding generations can only be based on the concept of intergenerational responsibility, insofar as the right to a balanced and healthful ecology is concerned. Such a right as hereinafter expounded, considers the rhythm and harmony of nature. Nature means the created world in its entirety. Such rhythm and harmony indispensably include, inter alia, the judicious disposition, utilization, management, renewal and conservation of the country's forest, mineral, land, waters, fisheries, wildlife, offshore areas, and other natural resources, to the end that their exploration, development, and utilization be equitably accessible to the present as well as future generations. Needless to say, every generation has a responsibility to the next to preserve that rhythm and harmony for the full enjoyment of a balanced and healthful ecology. Put a little differently, the minors' assertion of their right to a sound environment constitutes, at the same time, the performance of their obligation to ensure the protection of that right for the generations to come.